This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Hello everyone, I'm Leonard French, your favorite copyright attorney, and we're here with an update in the JW Apostate DMCA subpoena to Google. This one, which is the latest one, I think it's number 60 in the past few years. What hat am I wearing? I am wearing the oh heck hat, because we figured, oh heck. But so just a real quick recap, this is where Watchtower Bible and Tract Society, who is Jehovah's Witnesses, their organization and their lawyer, Paul D. Polidoro, it's his middle initial, they have filed what's called a DMCA subpoena. It's a little known provision of and a little used provision, actually, of the Digital Millennium Copyright Act that allows you to pursue an infringer's identity by subpoenaing their service provider, in this case, YouTube. JW Apostate was accused of, and it appears to be true, the accusation at least, whether or not it's copyright infringement is a whole other question, but he or she was accused of posting internal Watchtower videos of their meetings, and I think two of their sort of, I don't mean this in a bad way. You can decide for yourself whether it's good or bad, but for lack of a better word, propaganda videos, like advocacy videos for their own cause. So he or she posted those. I'll just refer to them as JW Apostate. JW Apostate posted those to their YouTube channel, and then got this DMCA takedown, series of DMCA takedown notices, and then a DMCA subpoena that have gone to YouTube. In a previous video about 2 weeks ago, I think it's almost exactly 2 weeks ago, because these response dates are about 14 days, unless the judge sets a different date. JW Apostate filed what's called a motion to quash, which sounds an awful lot like motion to squash, and I'm very used to having to hear this motion to squash the subpoena from potential clients. But motion to quash the subpoena is the legal language for asking a court to invalidate the subpoena or order granting the subpoena or something along the way that kills the subpoena. And so JW Apostate made arguments about having a First Amendment right to freedom of speech, having a New York and a California source shield law for journalists reporting, that kind of thing. By the way, since we're in the middle of this self-isolation situation, there are people who are going stir crazy and are just driving cars around the block at revving the engine and everything. I apologize if you can hear that. There's nothing I can do about it. It's been going on all day. It's also kind of a nice day, and so, the first couple days of spring, people really need to get all that pent-up energy out. Back to our story, though. So we're here today on Watchtower's response to the, shall we call it, spicy motion to quash, which accused Watchtower of being all sorts of bad things, bad actor, an overbearing religious organization, basically. I'm putting it very politely. Go watch our previous video and you'll be able to see what language JW Apostate used. So, without further ado, let's take a look at the DMCA subpoena to Google LLC matter before the Honorable Kathy Siebel. She is a Southern District of New York attorney Southern District of New York judge, district court judge. And she's the same judge that I had gone to her courthouse, to her courtroom, to watch one of the Richard Leibowitz copyright troll matters, where Richard Leibowitz had lied to the court about his grandfather's death and been basically caught, but tried for months and months and months and months to keep the court from finding out the truth about the grandfather's death, and then eventually had to show up with a pair of attorneys to defend him. And I think we're still waiting to see what the outcome of that is. Somehow Leibowitz survives all of these missteps, but That's a whole other story. We're going to get back to this one. Thank you, Kiefer Bentley, for the £5. Love the channel. Makes law reading fun and educational. That's what we're trying to do here. I know we're not perfect, but we're trying to make this fun and educational. This one is called the Plaintiff Watchtower Bible and Tract Society of Pennsylvania's Memorandum of Law in support of its opposition to the motion to quash. So basically, this is their memorandum of law in opposition to the motion to quash the subpoena. If they win, then they get the subpoena. So this is what you would write if you were advocating for the subpoena. And they say, Jehovah's Witnesses are well known for their distribution of Bible-based books and publications. After the creation of their website, jw.org, Jehovah's Witnesses transitioned to also utilizing digital media in order to accomplish their scripturally based ministry. Jehovah's Witnesses use Watchtower Bible and Tract Society of Pennsylvania to own its intellectual property. After the transition to using digital media, Watchtower experienced an explosion of internet-based infringements of its intellectual property. Thus, Watchtower undertook efforts to protect its rights. The instant subpoena is part of these efforts, and there is an affirmation of Paul D. Polidoro, their attorney. We'll get to that after this. When they say that they have undertaken efforts to protect their rights, that includes approximately 60 DMCA subpoenas that they have filed over the last few years. And we went over a list in the last video, and I'm not going to duplicate too much more here. JW Apostate, here in after the movement, which is how we refer to the moving party. They're the ones who moved for a DMCA subpoena, but the motion to quash, JW Apostate, of course, is movement. They're the ones who moved against the motion to quash, Movement is the motioning party for the motion to quash. They posted a number of Watchtower's complete videos. There was no transformative effort made in these postings. Rather, as is clear from the motion, they assert the right to unfettered use of Watchtower's corporate intellectual property. The filthy diatribe he or she submitted claims this right is grounded in reporters' shield laws and a First Amendment right to anonymous speech. Both arguments are without any legal support, and their motion should be dismissed. They, Watchtower, go on to say that California and New York shield laws are inapplicable. Movement, JW Apostate, asserts protection under California and New York laws protecting a reporter's source. While the rationale underlying the reliance upon California law is unclear, it is of no moment or no legal importance. Neither California nor New York provides the protection Movement seeks. Thank you, various cheeses. We have a cheese store here in Pennsylvania right near me called Cheeses of Nazareth, which I think that's appropriate to talk about right now. The case law and statutes they cited, JW Apostate, applies exclusively to the protection of sources. The subpoena does not order him or her to reveal any source. It orders Google to reveal identifying information about the account holder that infringed Watchtower's intellectual property. Thus, shield laws are inapplicable to this subpoena. Movement confuses a reporter's legal right to protect his source, or her source, with an imaginary right to protect a reporter's identity. Woodward and Bernstein long safeguarded Deep Throat's identity. That was not the adult entertainment, but a different, that was a different situation. I completely forget, but they were a source, I think, of against government corruption. Not entirely sure. However, there was no legal right for Woodward and Bernstein to conceal their own identity, assuming that Woodward and Bernstein were the journalists who were doing the report. Assuming arguendo that Movement was asked in the course of future litigation to reveal their sources, he could then provide his bona fides or bona fides as noted author and journalist and argue for the application of shield law protections. However, such a request at this juncture is premature and should be summarily denied. One thing I'd like to notice as an attorney is 0 cites. There are literally no citations here to any law whatsoever. Watergate, thank you. Thank you. Deep Throat was Watergate. They were the source of the Watergate whistleblower. Deep Throat was the whistleblower. So then they continue, there is no right to anonymously infringe intellectual property. Movement also seeks refuge in the right of anonymous speech. The law in this circuit, this is the Second Circuit Court of Appeals, which is New York, is clear. There is no right to anonymously infringe copyrights. However, First Amendment free speech jurisprudence fully supports this holding. To subvert the well-established protections accorded copyrights, Movement asserts the right of anonymous speech. In doing so, he or she ignores the fact that the United States Court of Appeals for the Second Circuit, so here we go, finally we get a cite, has held this inapplicable in the realm of copyright infringement. The First Amendment does not provide a license for copyright infringement. Thus, to the extent that anonymity is used to mask copyright infringement or to facilitate such infringement by other persons, it is unprotected by the First Amendment. And that is Arista Records citing Harper and Row Publishers v. Nation Enterprises, if you want to look up your sites. Now, we've studied a lot of fair use law on this channel, and fair use is the accommodation for free speech in copyright. And so unless JW Apostate is asserting a free speech defense, which I'm skeptical that would apply here. The JW Apostate YouTube channel seemed to be posting what I would call per se copies, or exact copies that automatically reach a level of copying that would be considered infringement. Even if there is a larger news reporting or commentary purpose, it's not apparent in the actual individual videos that were copied. They just seem to be exact copies, and that's not allowed by fair use law without a weighty, without a significant transformation and application of fair use. So you'd have to copy less than the entire thing. You'd have to make a transformative use, which is criticism, commentary, etc., usually in the form of some sort of overt criticism or commentary, but at least we saw in the Sargon of Akkad case that you could have a fair use even if there wasn't overt criticism or commentary, but rather sort of a title and an editing in order to make some sort of criticism or commentary point, and the audience came into it. So yeah, even if there's a contrary audience on YouTube that is critical themselves, the audience is critical of Jehovah's Witnesses or Watchtower or whatever, JW Apostate themselves doesn't appear to be making the criticism or commentary point. So it's sort of difficult to find for a fair use based on that alone. And then the whole video is copied for verbatim, bit for bit, whole video. No commentary, no shortening of the video to only make the criticism or commentary point on one particular part of the video or something. It is possible to make transformative use of an entire work, but not without making criticism or commentary on the work. And then there is a fourth factor, the market usurpation or usurpation factor, where is there a market for this video, and do the markets overlap, and does the JW Apostate copying diminish the market for the Watchtower video? And I don't know how much that's happening here, because the Watchtower videos were internal videos that were for their spiritual purposes, as Paul Polidoro just said, but the JW Apostate use was to kind of expose that it was kind of a whistleblowing itself. So not entirely sure that could even be considered a fair use. I would consider it a per se copyright until we got some kind of really good argument that it's a fair use. Arista, because we were just talking about the Arista case, completely supports the denial of Movement's motion, JW Apostate. Arista applied the test set forth in Sony Music Entertainment to a subpoena conflict. Assuming this standard also applies to a DMCA subpoena, the motion should be denied. Okay, well, they'd want to do more than assume it applies to a DMCA subpoena, but I'm pretty sure they think they're already going to win this one, so why put in, 24 pages of argument and citations and things? Yeah, I can sort of understand it. And if they don't win, what's the big deal? The videos were already taken down by a DMCA takedown notice, so really this is just whether or not they can conduct a prosecution of the JW Apostate channel, starting with whatever YouTube Google has as an identity for that person. We'll get to that too in a moment. Watchtower has established a prima facie claim of actionable harm, which is a basic copyright claim. It owns the copyrighted material that was placed on Movent's YouTube account. Further, Movent does not contest the fact that Watchtower owns the intellectual property that JW Apostate disseminated without license or permission. Second, the subject of the subpoena is specific. It requires Google to provide Movent's identity. Third, there are no alternative means for Watchtower to obtain the information. Fourth, Watchtower needs the subpoenaed information in order to properly assess and advance a copyright infringement lawsuit. They forgot a period there. Finally, Movent has no reasonable expectation of privacy. The Arista Court rejected a privacy claim as to the identity of the one who posted copyright material. In sum, Watchtower, having relied upon its statutory rights in obtaining a DMCA subpoena and having complied with the statute's requirements, has established a prima facie showing of concrete harm, thus satisfying Arista's requirements. Arista's holding has strong jurisprudential support in the Supreme Court anonymous speech jurisprudence. First, constitutional protections are accorded anonymous religious or political speech. Movent is engaged in neither. In fact, he is not personally engaged in any speech. Rather, he posts the religious speech of others contained in copyrighted intellectual property, and despite not being a speaker, thereafter equates himself to an anonymous pamphleteer. He misunderstands the protection accorded such speakers. Movent relies on McIntyre v. Ohio Elections Commission, a Supreme Court case from '95, to assert their anonymity. This misses the mark. Ms. McIntyre was engaged in her own political speech. She wrote her own pamphlets. She did not misappropriate the speech of others. She had the right to anonymity. Movent can say whatever he wants on his website and remain anonymous. However, Movent cannot engage in the wanton wholesale dissemination of complete copyrighted works and thereafter hide behind the shield of anonymity. And now I'll refer back to the Dark Spilver case, which was where Reddit got a DMCA subpoena from Watchtower, and the EFF fought for Dark Spilver's anonymity, but the thing Dark Spilver had posted on Reddit was much more closely related to a fair use. It was posted for criticism and commentary to an audience for criticism and commentary of ex-Jehovah's Witnesses, and it was, although one of the things was an internal chart that was factual and therefore not copyright, the court said, but the other thing, the back page of the Watchtower magazine, which was used for fundraising, that could have been considered a copyrighted work, but posting it was considered a fair use. So unless this is a fair use somehow, I don't see how this is going to be how the subpoena is going to be denied and the motion to quash granted. Let's continue with their conclusion and then the affirmation. Movent's reliance upon shield law protection and the right of anonymous speech is without merit. Watchtower respectfully requests the motion be dismissed and Google be ordered to forthwith comply. And so then what do we have as an affirmation here? This is an affirmation, which is a little weird. Usually these are done in the form of a declaration. I'm not sure what an affirmation is going to be. Let me look down here. Yeah, I don't see a swearing under penalty of perjury. So this is not a declaration. This is just a sort of statement. The lawyer is signing it, and lawyers do have a Federal Rule of Civil Procedure number 11 responsibility to only sign things that they're, willing to fight for and have done due diligence on, and things that are true and correct to the best of their knowledge. So I guess they're making this statement as a Rule 11 statement instead of as a declaration under penalty of perjury. Oh, wait, here it says it. I almost missed it. Declares the following to be true under penalty of perjury. So it is. It's basically a declaration or affidavit under under federal law. I am an associate general counsel of Watchtower Bible and Tract Society. As such, I am fully familiar with the facts of this matter, etc. This action arises from the infringement of Watchtower's copyrighted works. Watchtower reported the infringement to Google February 27th, pursuant to the DMCA takedown provisions. That's what that is. That's what that law right there is what you have to put into a DMCA takedown notice. Without knowing the true identities of the infringers who are allegedly posting Watchtower's copyrighted works, Watchtower is unable to defend its copyrighted works against these infringements. In order to uncover the identity of JW Apostate, Watchtower requested a subpoena under this law 512H of the DMCA, pursuant to the DMCA. In the application for the DMCA subpoena, Watchtower provided this court with proof that it was entitled to a DMCA subpoena. A copy of the copyright infringement notice that it sent was provided, a proposed subpoena, and Paul's sworn declaration stating that the purpose for which the subpoena was sought was to obtain the identity of an alleged infringer, and that such information could only be used for the purpose of protecting the rights under the DMCA. After reviewing Watchtower's request and all documents, the court found good reason to issue. Well, I don't know if the court found good reason. The court just has to make sure it meets the requirements, and in this case, I don't even think it's the court. I think it's the clerk. The clerk makes sure that you met the requirements, which are just administrative requirements, making sure you did the right form of things, that they don't actually verify the merit so much as they verify that you've complied with the procedural requirements of the law. So to say the court found good reason, I don't know if that's, I guess the good reason is that they complied with the procedure, but that's not to say that it has merit. I think it does have merit. I don't like to agree with Watchtower in this case, but I can't really find any way that I would, if I was defending this case, I'd be, what they say, if the law is on your side, you go, if the law is not on your side, you argue the facts. If the facts are not on your side, you argue the law. If the law and the facts are not on your side, you pound on the table. Watchtower has applied for copyright registration. That means that they don't have a registration, but at least in some cases it looks like, hang on, they have registrations for some of the items, and they have applications for others. So there was a case last year, Fourth Estate versus Wall-Street, I believe it was, that said you have to have copyright registration completed before you can sue over copyright. I am not entirely sure how that applies to a DMCA subpoena. I think you can still get a DMCA subpoena, and I know you can still issue DMCA takedown notices. And these were the works that were allegedly infringed. Although I thought it was only 6 works, there appear to be 9 works here. March 11th, Watchtower served Google with the DMCA subpoena. March 12th, a motion to quash was filed. March 18th, Google advised that it will await the court's ruling before taking any further action. Wherefore, plaintiff Watchtower requests the court issue the order denying the motion to quash and ordering Google to comply. So, what happens from here? The court will consider the parties' submissions. In the Southern District of New York, I believe there is another 7 days allowed, and then JW Apostate can reply to this opposition to its motion. That's not legal advice. If JW Apostate is watching, you got to go look that up in the court's local rules and the judge's rules of procedure as well. The civil rules and for both the court system, the Southern District of New York, and the local rules for Judge Kathy C. Bell. And it should be in there someplace about when you would have to respond. What could happen from here, though, if the court, I assume the court is going to grant the subpoena and deny the motion to quash, and Google will comply with providing whatever they have. Now, Google doesn't have to identify JW Apostate. Google has to provide whatever information they have that is identifying JW Apostate. So if JW Apostate signed up with their personal Google account or a Google account that has their name and address and telephone number and email and all that, and if they filled out a W-9 form for monetization and all that for tax purposes and all that, Google probably has to provide the identity part of that to Watchtower, to Paul Polidoro. If the person has figured out how to open a YouTube account without providing personal information, using like a burner email account and using a false name and address or whatever YouTube requires these days, which I believe is a Google account. So if there's a Google account attached to a YouTube account and and it doesn't have any good information in it, then Watchtower gets the false information, because that's what Google will have, and that's what Google will have to provide. So it's really going to depend on what in the world Google has, whether Watchtower then will be able to pursue a case. And even then, it's possible that upon conducting their investigation, they might realize that it's not worth pursuing or something. And even then, what are the damages? The damages could be a minimum of $750 for works that were properly registered before the infringement commenced. Maybe a court might agree that if there was continuous infringement and then the registration was completed, that infringements after the registration was completed could be considered statutory, and that means a minimum of $750 per video. But other than that, I'm not sure that the judge is going to agree that this is the kind of egregious willful copyright infringement that requires a $30,000 or $150,000 judgment per video. I don't think so. We've seen a couple videos. We've seen a couple situations, especially Leibowitz situations, where the Leibowitz or another copyright plaintiff gets all the way through their copyright infringement lawsuit and gets $200 because the person did their best to try and figure out if there was a copyright active on a particular work, and they got it wrong, but they had tried their best, and so that might be considered innocent infringement. If it is non-willful infringement, then it's $750. Sometimes a court will say that a willful infringement is 3 times multiplier of whatever the base damages is. So a minimum $750 times 3, a minimum of $2,250 for willful copyright infringement. So it's an interesting situation. I'm hoping that Google doesn't actually have any identifying information, and so this will end here. If it does not, of course, we'll bring you updates. We have real-time updates on these, which is how we were able to get this, even though it just came out today, the 26th. So yeah. So what do you think? Let us know in the chat and in the comments below. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education channel. And I say that tongue-in-cheek. There are lots of great creators these days, and I know Devin from Legal Eagle and Steve Lato from Lato's Law, and a bunch of others, Viva Frey and Nate Brody and Richard Hogue are all great legal video creators. I'm sure I'm forgetting somebody, and I'm sorry if I forgot you. But we like to call ourselves your favorite copyright attorney. So thank you for watching. I would like to thank our supporters at the $50 level on patreon.com/ljfrench and sponsors.com/law, and now Floatplane and now YouTube memberships. Thank you in the month of March to Wes Delj, Aspernari, Video Remonetized, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Blackleaf, Joe Tyson, Benjamin Hitov, Stephen Ottah, Cute Grills in Your Area, Longreach Jones, Zachary Chaney, Mullen PC, and Anders Thorenfeldt. Thank you to Midnight Rose for the $10 super chat. Thank you to for amazing educational law review videos, and thank you to Kiefer Bentley and Various Cheeses for your super chats as well. The $5 plus supporters, which includes the $50 plus supporters, are scrolling on this LED panel behind me, which is one of our fun things that we do and update every month, and will be in the description of the video. Normally there's a crawl here, but I don't have the crawl set up as a thing to do on a live stream. We also now have a store open, and we have some merch for you. We recently released this t-shirt, Will Work Pro Bono, with Ilsa and Nico on it. That's Ilsa on the right and Nico on the left. So Will Work Pro Bono, pro bono as in free legal service. So I thought that was cool. And then if you remember the R. Kelly story from last year, he wrote, "I do not accept this offer to contract, and I do not consent to these proceedings," in his lawsuit response, I believe it was, to a lawsuit against him. So we have some stickers available there for you as well, and those are at our Teespring store, which should be in the description below. So again, I'm Leonard French. Thank you very much to Emma Kieria for your $20. You are amazing, they say. Thank you. Really appreciate it. You're amazing too. Anyway, I am going to go and keep this one short so that people might actually watch it and not see an hour-and-a-half live stream. I love you all. I will talk to you later. See you in the next video, which would be tomorrow morning. And I loved making the unicorn. The unicorn one's great. Go watch the recent VOD release on our channel, the unicorn emergency. Court has responded to a unicorn emergency. Love you all. Have a good one. Bye.